Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, we're going to get to talk about a significant challenge to the federal regulations on automatic weapons or machine guns. But what I really like about the brief I'm going to talk to you about today is it does exactly what we try to do here at Washington Gun Law all the time, which is take something that appears to be incredibly complicated and simplify it so that everyone could understand it, because oftentimes it really is that simple. Now, I know that some of you think it's just as simple as these four words. I can assure you it's a little bit more complicated than that, but not as complicated as many people, including some of these district courts, make it out to be. But sometimes the most effective argument you can ever make is perhaps the most straightforward, the most simplistic, the most realistic argument. So today, let's spend a few minutes and let's talk about the simplest argument yet to deregulate machine guns. Okay, America, the case we're talking about sits before the Fifth Circuit Court of Appeals. It is a once successful challenge coming out of the Southern District of Mississippi to the ban on individuals possessing automatic weapons. The case is United States of America v. Brown. Now, today we're going to be talking about an amicus brief, a really well-written amicus brief that is brought to us by the National Rifle Association, the Firearms Policy Coalition, and the FPC Action Foundation. Now, we have covered this case once before, and the arguments at the trial court level were as straightforward and simplistic as the arguments made here in this memorandum, which is, simply put, a machine gun is a bearable arm, and therefore the text of the Second Amendment covers the possession thereof. There is a historical tradition of being able to ban certain types of firearms and other weapons so long as they are both dangerous and unusual. However, because machine guns are owned in such a number and to such a degree by lawful and responsible gun-owning Americans nationwide, there is nothing that is no longer unusual about it, and therefore this statutory scheme has no historical analogs. But for all of these courts out there that are trying to figure out, is this part of Bruin Step 1 or Bruin Step 2, or is it in common use, or is it in common use for self-defense, or is it particularly dangerous, or is it a more nuanced approach, or is it more relevantly similar, or any of the other crap that all of these courts either use or make up out of thin air to uphold bans, what I love about this memorandum is it walks through the basics, okay? This is constitutional Second Amendment Protection 101. Let me share with you what the amicus party states here. When the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. The government must then justify its regulation by demonstrating that it's consistent with the nation's historical tradition of firearm regulation. So the first question we have to ask ourselves, because apparently a lot of district courts have a tough time with this one, is what exactly is a bearable arm that would be covered by the Second Amendment? Well, the amicus party correctly states, the Supreme Court has already recognized that the Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of founding. Thus, Heller identifies a presumption in favor of Second Amendment protection, which the state then bears the initial burden of rebutting. So when we are talking about any type of bearable arm, the answer is and always will be, yes, the activity should or is presumptively covered by the Second Amendment. Can that presumption be rebutted? Yes, it can, but only through historical analogs. But if there are any limitations to Second Amendment protections, that is not part of determining whether or not the Second Amendment presumptively covers the activity. It's part of the historical analysis necessary to justify the subsequent ban, as the amicus party points out. While it may be true that the right secured by the Second Amendment is not unlimited, any limitations on bearable arms must be considered in light of this country's historical tradition of firearm regulation, not as part of the plain text analysis. Okay, and then this is also very important, especially to a lot of these lower courts just upholding civilian disarmament legislation, is that the whole dangerous and unusual will be part of the historical analysis, okay? It is not part of step one. As the amicus party correctly points out, The Supreme Court has recognized a tradition of regulating dangerous and unusual weapons. In doing so, the court established that the question of whether a particular arm is dangerous and unusual must be considered in the historical rather than plain text analysis. So understand that what the amicus party is correctly arguing is that if it's an arm, it is presumptively covered by the Second Amendment. A dangerous and unusual weapon is still an arm, okay? It may be banned if it's dangerous and unusual, but it is still an arm. So some of these things that these are not bearable arms that are protected by the Second Amendment that we see out of the Seventh Circuit, the Fourth Circuit, places such as that, it's complete crap. As the amicus party points out, indeed, Heller did not say that dangerous and unusual weapons are not arms, but rather that the relevance of a weapon's dangerous and unusual character lies in the historical tradition. And it does not matter how dangerous or particularly dangerous a court may believe an arm to be. If it is an arm, it is covered presumptively by the Second Amendment. As amicus points out, because the specific bearable arm is not relevant to the plain text, the characteristics of the specific arm, that is, whether it is dangerous and unusual, cannot be assessed in the plain text analysis. So then, of course, we get a lot of courts that try to decide, well, what history do we need to take a look at? Does it need to be a little bit more of this, a little less of this? And obviously, they will put their thumb on the scale of whatever they need to achieve their results. But the truth of the matter is, for all the lower courts out there, is that you don't have to do any historical analysis. It's been done already. It's been done for you. All right? Why reinvent the wheel? It's already been done and it's in clear case law. And so, as the amicus party correctly points out, the historical tradition of prohibiting the carrying of dangerous and unusual weapons is the only traditional regulation Heller identified in its historical analysis of restrictions on particular arms. That's right. The test to determine whether or not there is a historical tradition of permitting a ban of this nature is this simple as this question. Is the arm we're talking about dangerous and unusual? Not dangerous or unusual, dangerous and unusual. It is a conjunctive test. And there are at least two well-known Supreme Court justices who appeared to be 2A scholars as well, who have confirmed this exact rule of law. Justice Thomas, who authored the Bruin opinion, joined by Justice Scalia, who authored the Heller opinion, provided additional confirmation that if either the dangerous or unusual element is not satisfied, the arm cannot be banned. Yes, for all of these courts that are just going through way too much history or bringing in historians to help you, you guys are doing way more work than you need to. This is a much easier process because amicus correctly points out, but in this case, the historical work has already been done. Binding Supreme Court precedent lays out the contours of the test the government must meet. Drawing from America's historical tradition, Heller held the Second Amendment protects arms that are in common use at the time. And then, of course, if an arm is, in fact, in common use, well, then there's nothing unusual about it, right? Makes perfect sense, as amicus more eloquently points out. Of course, arms that are in common use are necessarily not dangerous and unusual. Therefore, the pertinent Second Amendment inquiry is whether the arms at issue are commonly possessed by law-abiding citizens for lawful purposes today. And so, since we can agree that every weapon is dangerous or certainly potentially dangerous, and, we'll just give you that in arguendo, then I guess it really just comes down to the unusual element. And that's really just a numerical game, isn't it? I mean, it would seem that way, and certainly that's the way amicus puts it. At the district court, Mr. Brown asserted there were more than 740,000 machine guns lawfully possessed in the United States in 2021. The government did not point to any other number and presented no argument or explanation for why such a figure is not somehow common. And here is a huge point that's made by the amicus party, but it's really based in a lot of common sense, which is, we can heavily regulate or even ban these items, but over the course of time, if people lawfully come into possession of them, at some point, you can't say that they're unusual anymore. As amicus correctly points out. In other words, while the historical tradition limited to dangerous and unusual weapons identified by the Supreme Court remains a consistent principle, the Supreme Court has also made clear that the arms at issue in the right are not limited in time, just as forms of speech under the First Amendment or protections of privacy under the Fourth Amendment are not so limited. And this is a critical point. Thus, even if these arms were considered dangerous and unusual at some point, the government is required to demonstrate that they are dangerous and unusual today. And that was the exact burden that the trial court had held the government to, and the government had failed to meet their burden, and therefore a ruling in favor of the plaintiff Brown. So listen, I get that a lot of these district court judges, lower court judges, state Supreme Court judges, and so forth who want to uphold civilian disarmament legislation are probably not tuning into Washington gun law. I get that. But I do want all of you to know that you're making your jobs a lot more difficult than they really need to be, because a lot of this work has already been done for you. And as the Amicus Party correctly points out, when it comes to determining what can be banned and what cannot be banned, the test is really this simple. The inquiry ends there. Heller already explored the relevant history and found the only way to ban possession of a firearm is by demonstrating that it is dangerous and unusual and therefore unprotected by the Second Amendment. And that, my friends, is how you take a very politically hot issue, deregulation of automatic weapons, simplify the equation, simplify the legal approach, pound away at clear case law and constitutional principles, and point out simply that, you know what, the trial court got it right in this case. The case, once again, is United States of America v. Brown. We're going to link that up down below. Remember, we're linking up all the amicus parties down below so that you can show them some love as well. If you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information down there in the description box. If you got an idea for a video that we should be doing around here, you click on that link right there and you tell us all about it. If you want to subscribe to the monthly newsletter, the ability to do that is down there in the description box. And then finally, and most importantly, let's everyone remember that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.